My name is Nicolene Skuman-Low, and I'm an attorney, conveyancer, notary public, and mediator. I practice as such here at Skuman Law Incorporated, based in Cape Town, South Africa, where we proudly serve the legal needs of the entrepreneur. Today, I would like us to talk about rogue directors, or rather, how to remove one if you have one. In a previous video, I took you through some of the best practice tips as to what is needed to be observed in order to be a good director, so that you never run the risk of becoming labeled as a rogue director. So feel free to navigate on our YouTube channel or Facebook page and look at that video if you're unclear as to what we mean when we speak about directors' duties and it being breached. Now, of course, there could be many reasons for you wanting to remove a director. There could be a breach of duties, which is very serious, or there could be a breakdown in the relationship. Unfortunately, these things are never simple, as they are never simple in respect of an employee either. So, given the fact that in smaller companies we are all very aware of the fact that shareholders and directors are often the same people, it is crucial for you to keep in mind that although it's the same person, it is two very separate relationships that need to be separated or terminated in a very different way. So this is not going to deal with how you remove a shareholder. Shareholders cannot be removed as such. There's no mechanism to remove unless, of course, there's a mechanism in your shareholders agreement. But again, please do take advice and do not simply make any unilateral changes to that side of things. When we talk about directors, there are two types: executive directors and non-executive directors. Executive directors are those that are also employed with the company. And generally, they would have a service level agreement or an employment contract together with their appointment on CIPC records as a director. So, in many instances, it is actually two distinct relationships that need to be severed in separate ways or through separate procedures. The labor legislation would need to be observed in terminating the employment relationship. Again, if you're not sure whether there is one, best to seek professional advice. There needs to be a proper procedure, a hearing, etc. In terms of removing the director, there are two mechanisms in the Companies Act that can be utilized. One is a director mechanism. In other words, the remainder of the board would follow a process very similar to an employment disciplinary hearing, and would then give the director reasons why they would want to remove him or her and give them an opportunity to state their case. Similarly, there's a mechanism where the body of shareholders can decide to remove that director at a shareholders meeting. Generally, there's no hearing that goes with this, but again, if the director so requests reasons, it is usually preferable to have them ready, even if they are not specifically requested, so that you can justify the decision that is ultimately being taken. So again, properly minuted, properly executed, and then of course the removal will follow. Now, removing from the CIPC records usually entails either a resignation from the director concerned or a resolution to be taken either by the board, if it was a board procedure, or by the shareholders concerned. And these need to be submitted to the CIPC in order for the records to be updated. And of course, this is quite crucial to happen. There could, of course, be a situation similar to this, where, of course, we are dealing with a non-executive director who is not employed. So, of course, the employment situation will not ensue, but still a procedure would need to take place, either on board level or on shareholder level, in order to remove this person. Again, often non-executive directors are not engaged with a proper contract, and this is really where it becomes absolutely crucial to ensure that expectations and roles and what they are supposed to be doing is clearly outlined in an agreement. It goes a long way to resolve any disputes or to proceed with removals if these things are all properly recorded. So, for any advice regarding the removals, what your options are, if you're unsure whether you're dealing with an executive or non executive director, please feel free to contact us. Feel free to comment, like, share, ask any questions in the comments box below, or go to our website filled with resources, all free of charge, ranging from podcasts or articles to videos like this. Feel free to make use of it. It can be found at www.skumanlaw.co.za. We also have an online contract builder tool where you can generate a range of different directors' resolutions, also find shareholders' agreements and MOIs at fractions of the price. In fact, about 10% of the usual price, just by cutting out the human element. So, for more information about that, go to www.skumanlaw.co.za/online legal services, or to access the platform directly. Registration is completely free of charge. Go to www.skumanlaw.com. Look forward to speaking to you again soon. Thank you for joining us.